India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Shapoorji Pallonji Group files plan in top court to part ways from Tata Group for Rata division of assets sought of Pallonji Group. In honour killing cases, Punjab Haryana High Court calls for details of pending cases, says fast-track probe by special investigation team needed. In a significant move, Punjab Haryana High Court asked state to give details of corrupt police officers, their place of posting and numbers. And in actor assault case, a prosecution tells Kerala High Court that victim was harassed in open court. 20 lawyers were present despite in-camera proceedings.
India Legal presents Courts Roundup.
And the Shapoorji Pallonji Group has sought a formal separation from Tata Group in the Supreme Court, proposing that its stake in Tata Sons be swapped for a pro rata stake in the Tata's listed companies, and the two conglomerates have been embroiled in a legal battle since 2016 when Cyrus Mistry, second of the family that controls the SP Group, was sacked as chairman of Tata Sons. The Shapoorji Pallonji or SP Group, which is the largest minority stakeholders in Tata Group, believes it is necessary to separate interests from the auto to steel conglomerate.
The Shapoorji Pallonji Group has filed an application before the Supreme Court detailing a separation proposal seeking division of assets and share in listed entities of Tata Sons. This separation plan filed before the Supreme Court highlight that Tata Sons is a company comprising two groups, which the Mistry family's stake stand at 18.37% of the equity share capital. Seeking to sever the decades-old association with Tata Group, the Shapoorji Pallonji Group has sought a pro rata division of all assets. Shapoorji Pallonji Group has also sought a direct stake in all of the listed entities of the Tata Group and is seeking a pro rata share of the brand value to be adjusted for net debt. The application also proposes the valuation of all the unlisted assets to be done by a neutral third-party agreeable to both the sides. Shapoorji Pallonji Group backs its proposal for separation in its application. The proposed separation, the SP Group says, is different from a buyout under Article 75 of the Articles of Association, which provides for a forced transfer of shares, an inherently oppressive measure. Through its proposal, however, SP Group claim that there are benefits for both sides. This considering there would be no valuation dispute in a scheme for proportionate separation of assets, while the control would remain in the Tata Group. The Mistry family's stake in each of the listed entities would stand at less than 10%, except in Tata Consultancy Services, TCS, where it is likely to be little over 13%. Moreover, a largely non-cash settlement would also be quicker to implement with minimal disruption to the operating companies. The scheme for separation is proposed on the apprehension that the SP Group's interest as minority shareholders will not be protected in Tata Sons in the current environment. Questioning Tata Sons' action thus far, SP Group claims that the company has made it clear that it would go to any length to prejudice SP Group's interest, which laid down the groundwork for the Mistry family seeking the division. The appeal filed by both Tata Sons along with its various entities and Director Emeritus Ratan Tata, as well as Cyrus Mistry against the December 2019 decision of the National Company Law Appellate Tribunal (NCLAT), through which Mistry was reinstated as the executive director of Tata Sons, remains pending before the Supreme Court. The court, while agreeing to hear appeals by Tata and a cross appeal by Mistry, had clubbed the litigation together and will hear the same at length. Earlier this year, the Supreme Court had asked Shapoorji Pallonji Group to maintain status quo as regard pledging of its share in Tata Sons for raising of funds. Tata Sons had opposed such a pledging on ground of having the right of first refusal. The Tata Mistry dispute, which reached Supreme Court in January this year, is likely to be taken up for hearing on 2nd November. Bureau Report.
When the test identification parades are held in police presence, the resultant communication tantamount to statements made by the identifiers to a police officer in a course of investigation, and they fall within the ban of Section 162 of the Code of Criminal Procedure, and the Supreme Court has held. In this case, the accused Chunthu Ram and co-accused Jagan Ram were convicted in a murder case by the trial court. The High Court, referring to the testimony of an eyewitness, acquitted Jagan Ram. Identification of the Lungli by film Sai was yet another evidence used against Chunthu Ram. While considering a criminal appeal, the bench noted that there was presence of the police during the test identification parade. It was further observed that to establish the presence of Chunthu Ram at the place of incident, the court relied on the test identification parade and the testimony of Film Sai. The court said that the test identification evidence is not substantive a piece of evidence but can only be used in corroboration of statements in court. Such tests are meant for the purpose of helping the investigating agency with an assurance that their progress with the investigation into the offence is proceeding on right lines. In this context, the bench, comprising Justices Sanjay Kisan call the statement of witnesses recorded by the police under Section 162 CRPC during investigation cannot be used for seeking corroboration or assurance for the testimony of a witness in court. The court also observed that the witness Bhagat Ram admitted to having poor eyesight, and through his cross-examination it was elicited that witness is incapable of seeing things beyond 1 or 2 feet. Taking note of all this, the bench acquitted the accused. And we are now joined by Advocate Divyanshi for more updates.
Yes. In this case, the Apex Court has held that when the identifications are held in the presence of police personnel, the resulting communications tantamount to statements made by the identifier to a police officer in course of investigation, and they fall within the ban of Section 162 of the Code of Criminal Procedure. The court has also held that the test identification evidence is not substantive piece of evidence but can only be used in corroboration of statements in court. Further, taking note of poor eyesight of the witness, that he cannot see beyond 1 or 2 feet, the bench acquitted the accused.
Well, thank you, Divyanshi, for the update. Punjab Haryana High Court has given important instruction on honour killing cases. The court has said that fast-track investigation by SITs is needed. The court has called for details of pending cases related to honour killing.
The Punjab and Haryana High Court has directed the Director General of Police, DGP Haryana, to file an affidavit regarding the number of honour-killing cases registered in the state in which trial or probe is pending, and which steps have been taken to fast-track the same. The bench of Justice Arun Kumar Tyagi has further asked the state DGP to spell out the steps taken for the protection of the survivor wife or the husband and other important witnesses in the completion of the chain of circumstantial evidence incriminating the accused responsible for commission of the heinous offence. The FIR was filed regarding the abduction of Sunita Rani and Dharambir. It was lodged by Rai Singh on 1st June 2018. Dharambir was subsequently murdered by the person who had abducted him. Notably, the case involves allegation of honor killing of Dharambir by person whose honor was allegedly subjected to disgrace by the deceased by performing marriage with their relative Sunita Rani. Statements of Sunita were recorded under 164 of CRPC twice, and she had also named the person with whom her husband Dharambir was last seen by her. The court noted that no effort were ever made for her protection despite the fact that she was an important witness against the accused, all or most of whom were her relative. The police has stated in its reply that 15 accused were involved in the present case in the commission of the offences mentioned above, out of which 12 accused have been arrested so far, but 3 accused, namely Nekiram, Balwant and Sher Singh, are still absconding despite expiry of more than 2 years. The court further noted that there was no mention in the reply as to what steps regarding getting them declared as proclaimed offenders and attachment and sale of their properties have been taken. Court's order, the High Court cited the Apex Court's ruling in the case of Bhagwan Das vs State of Delhi, wherein the court had noted that there is nothing honorable in honor killing, and they are nothing but barbaric and brutal murders by goated person with feudal minds. In our opinion, honor killing, for whatever reason, come with the category of rarest of rare case deserving death punishment. It is the time to stamp out these barbaric feudal practices which are a slur on our nation. This is necessary as a deterrent for such outrageous, uncivilized behavior. All persons who are planning to perpetrate honor killings should know that the gallows await them. Lastly, the court directed that copy of the order be sent to the Director General of Police, Haryana, for requisite compliance. The DGP has to submit the relevant detail by 10th November. Interestingly, a 2-judge bench of Supreme Court of Pakistan, comprising Justices Qazi Faiz Esa and Sardar Tariq Masood, had recently opened that the killing of women in the name of honor had never been an honorable practice and that such murder should not be categorized as honor killings. Bureau Report.
The Punjab and Haryana High Court has ordered the Additional Home Secretary of the state to file an affidavit in November 16, informing how many tainted police persons or officers are posted at all positions in the police. Information on their current deployment, their full details have also been sought. The petitioner's counsel in the case, Balbir Saini, told the bench that in the previous hearing on the order of the High Court, Punjab Deputy Home Secretary Vijay Kumar had given an affidavit in the High Court submitting the list of 822 corrupt police personnel. There are about 18 inspectors, about 24 sub-inspectors and about 170 ASI. The rest are head constables and constables. Advocate Saini said that it is only lower-level officers. No information was given about the PPS and IPS officers. On this, the High Court has now ordered the Additional Home Secretary to give full details of the cases registered against all the officers, the status of investigation in the FIR, and where these persons and officials are posted. A single bench of Justice Upender Singh Grewal of the High Court had sought information from the Punjab government about the police officers and persons against whom the FIRs were lodged, and he is still in service. The court also ordered the government to give information about where those workers are currently posted, what kind of cases are registered against them and what is their status, but the Punjab government has not informed the court about the high officials. The High Court, while hearing the petition, issued notice to all the other defendants, including the government of Punjab, seeking an answer. The Kerala High Court heard transfer petition moved by the victim and prosecution in the case concerning the abduction and sexual assault of an actress in which actor Dileep is also accused. So both the matters were heard today by a single judge bench of Justice V.G. Arun. The prosecutor began by speaking about instances of the victim being harassed in open court and also told the court that the service of copies of certain forensic reports to the prosecution was dispensed with. The prosecution and the senior counsel agreed to file a detailed affidavit which stated verbatim all that transpired in the court during the trial, and Justice Arun asked the prosecution why the charges of harassment had not been brought to the attention of the trial court earlier. The counsel responded that they had made oral submission as and when instances of irregularity took place. They had desisted from filing a transfer application in order to complete the trial at the earliest. No action had been taken by the trial court when the instances were pointed out. They emphasized, and this is an unusual case where even the prosecution alleges bias on the part of a trial proceeding. The counsel declared. Justice Arun also asked the senior counsel for the victim whether an affidavit had been filed by the victim accompanying her petition for transfer, as mandated by Section 407(3) of the Code of Criminal Procedure. The actor and his associates are being tried for hatching a conspiracy to take revenge on a female actor in the Malayalam film industry by having her abducted, sexually assaulted and photographed. The Guwahati High Court has directed the NRC State Coordinator to file a comprehensive affidavit explaining how a section of ineligible persons managed to include their names in the National Register of Citizens. The court asked NRC State Coordinator Hitesh Dev Sarma to file the affidavit within 3 weeks and list the case immediately thereafter. Here's a report. The Guwahati High Court, while hearing a writ petition by Rahima Begum against a Nalbari District Foreigners Tribunal order declaring her a foreigner, the High Court bench comprising Justices Manojit Bhuyan and Soumitra Sekia said they have noticed that many names were included in the NRC by flouting laid-down norms. Guwahati High Court directed the NRC State Coordinator Hitesh Dev Sarma to file a comprehensive affidavit explaining how a section of ineligible persons managed to include their names in the National Register of Citizens. The order said, let the Assam State Coordinator, NRC, file a comprehensive affidavit and bring on record the situations along with necessary particulars, whereby inroads into the National Register of Citizens may have been created by individuals who are undeserving and not legally entitled to be included in the NRC. The affidavit will not be confined to Nalbari district only, but contain details of all other districts across the state as well, the bench said in its October 19 order, which was uploaded recently. The court further said, an issue of great importance is noticed in the present case. It is not a solitary instance, inasmuch as in a number of cases we have noticed and recorded similar issues appearing. The bench noted that the name of petitioner appeared in the National Register of Citizens even when proceedings against her had been initiated and continued on the basis of reference made by the Nalbari Superintendent of Police. The final NRC list was released on August 31, 2019 by excluding the names of 19,06,657 persons. A total of 3.11 crore names were included out of 3.30 crore applicants. Bureau Report. And that's it for Courts Roundup today. Thank you for tuning in and keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.